Courtroom Observation Presentation by Ashley Henry. Frame of the observation. Interactions between courtroom actors. The judge is to simply preside over the proceeding, see that the order in the court is maintained. They also determine if the evidence that is presented for any of the parties can be legally used. The judge also provides instructions to the jurors when it comes to the deliberations and the standards of the case. Then they also determine the facts of the case and then decide a fair sentence to the criminally convicted. The court reporter, they are by the witness stand and they usually type the official record of the trial on a machine, which is called a stenographic machine. This federal law requires that a word for word be made at every trial. They also provide a written transcript of the proceedings and the reviews. The attorney, their role is to bring out the facts that puts their client's case in a favorable light for each party side. They want to provide the facts and evidence in a manner where the jurors will decide the fate of the probable guilty parties if it's in a criminal court trial. The parties are present at the council tables with their attorneys. The parties are the defendants and the plaintiffs. The courtroom deputy is the one who administers the oaths of any of the witness or marks of exhibits and helps the judge ensure that the courtroom runs correctly and smoothly. Case 1, State of Indiana versus Client X. Client X is represented by a real person, but we're not using their name. Demographic characteristics of the defendant, estimated age of the defendant. Her age was not given, but she did look around her 40s and like her 40s to mid 40s. Her race, she is Caucasian. She is a female. Her behavior, she didn't really just seem to care what was going on during the status conference and was giving everyone in the courtroom disrespectful looks. When the judge asked her questions, she replied with short one-word responses. For example, during the observation, the judge asked her if she knew what she was charged with, and she just answered, "Yep," and rolled her eyes to the judge, showing that she had little to no respect for the judge. What happened is she had a level 6 felony, um, and she was charged with possession of a narcotic drug, possession of paraphernalia, and she also already had a prior conviction. The type of proceeding is that it was a virtual status conference. The duration of the conference was about 25 to 35 minutes, and the location was in the Elkhart Circuit Court here in Indiana. Um, a status conference is defined to be a court-ordered meeting with a judge where they decide the date of the trial or to get updated information on a defendant for ongoing court conditions or personal life conditions. Some more courtroom information about this um, specific case. Judge Z, again, not using the judge's real name, uh, was flexible when it came to scheduling the next status conference for the defendant and for her attorney. Was fair to the defendant, very, very fair and lenient. Um, he was cracking jokes in the courtroom with all the courtroom staff. Um, and her attorney, um, answered all the questions to the judge fairly and was very respectable and um, seemed to look out for the best interest of his clients and what she needed. And my personal expectations, what relief punishment was the prosecuting attorney seeking against the defendant? The prosecuting attorney really wasn't trying to see any relief or punishment towards the defendant due to this only being a status conference and the trial being scheduled still. Um, a personal resolution idea regarding this case. Um, Judge Z was very clear and made sure that Client X was made aware of what she was being charged for and what her next upcoming status conference or when her next upcoming status conference was going to be, and that her jury trial was going to be set in August of 2024. Um, and then my second case observation that I did was State of Indiana versus Client G. Again, not using the client's real name. Demographic characteristics of the defendant. His estimated age was about his mid 30s, about between 35 to 39. He was Caucasian. He was a male. His behavior is he seemed very remorseful and regretful about the position he was in and the actions that he made. He seemed willing to put in the work for requirements set out for him since he violated the terms of his parole. So he didn't have to be incarcerated again. So what had happened was he violated probation. He fled and left Shelby County, where his probation was, and he went to Bartholomew County because he went to see his physician regarding his medication for his depression and other medical or mental health related issues. And he also already had a property down in Bartholomew, so he went to go get retrieve his belongings because he didn't have any in Shelby County. Um, so the type of proceeding, it was a virtual probation violation hearing. It lasted about 30 to 40 minutes. The location was the Shelby Superior Court here in Indiana. And the probation violation hearing is when the prosecutor will bring to the judge the details and evidence of the defendant who didn't follow the terms of their probation. So, some more courtroom information regarding this case. Judge L, again, not using his real identity, seemed impartial and fair towards client G's circumstances. He gave them recommendations on how he could switch up his life around and mentioned incarceration if he broke the terms of his probation again. I just thought this was very interesting because most judges don't give second chances to many defendants regarding breaking probation, and they like if a person breaks probation, usually they'll go back to jail. But this judge was very lenient and gave him a second chance. My personal expectations for this one was what relief punishment was the prosecuting attorney seeking against this defendant or against the defendant. The prosecuting attorney wasn't trying to see any relief or punishment towards the defendant except that they follow through with the parole. Um, did the terms offer a defense or present mitigating circumstances? The mitigating circumstances made for the defendant was that since he was suffering from an opiate addiction and mental health issues, they sentenced him to a rehabilitation program or housing to overcome the addiction and help better his mental health problems. Personal resolution idea regarding this case, I feel like both client G's attorney and Judge L served him to their highest best possibility by helping him and making sure that he has a life that isn't behind bars and that he can help and that he can get the help that he needs to be an upstanding citizen, and that is not burdensome by the need of drugs for his depression or having to deal them to make money like he was previously. So some similarities and differences between these two cases that I noticed was two similarities was both judges gave the defendants the same standard statement about the process regarding if the defendant didn't agree with their sentencing, that they could try to fight it or appeal with one of the upper court divisions down in Indianapolis. Both judges were fair to each of the defendants that was brought up in front of them and was trying to look out for their best interests while making um, sure justice is served based on the felonies and misdemeanors that they may have. Um, Two differences between these two cases was case one, the setup when watching an Elkhart was different. It was more of a live Zoom call setup of the courtroom. The person facing the charge can call in from the jail cell or they can call in from the comfort of their homes. Um, Also, there were many different screens in the courtroom. There was the jail like the actual jail, um, where they could call in, and then the background of the person's house when they were calling in for the status conference or whatever initial hearing they had. Case two, compared to when I watched from Elkhart in Shelby County, it was an actual live feed of the courtroom. The person facing the charge is in person, standing in the courtroom in front of the judge, while their attorney is either right beside them or at one of the tables. Um, and they are there's only one camera view of the count taking place, so you can see the judge and the defendant, and then possibly the attorney. And then based on the course material that was provided, there's these different types of proceedings. There's the arraignment, the bond hearing, a pre-trial conference, and then the jury trial. Excuse me. Being able to identify members of the courtroom, the judge with the criminal court proceedings, you were able to still see the judge's bench seat. It was on camera. And then you have the attorneys, the camera pointed out each attorney's table for both the defendant and the plaintiff. And then the focal concerns theory for client X, she really was the only one that demonstrated toughness within the focal concerns theory. She was proving that she was tough and that she didn't care what her possible fate could be at her jury trial. She was proving that she didn't care during the status conference, and was very, like I mentioned before, had no respect for the judge. Didn't address him as your honor. Just said yup and rolled her eyes. Elements of community. There's an easily routinely flow to the courtroom process, addresses local problems and looks out for the safety of the local community, does everything in the best interest of the individuals of the community, and just makes sure that justice is properly served. So the elements of a pre-trial or trial process. We'll start with the pre-trial process. You start with the agreed case statement, witness list, exhibit list, motions and limine, voir dire questions, and jury selection or jury instructions and selections. Both judges have a say, or both attorneys have a say in jury selection. Trial process. You start with the opening statements, presenting prosecution and plaintiff's evidence, presenting the defense's evidence and cross-examination, and then you go into closing arguments, and then the jury's verdict, which could take a couple hours, or it could take a few days. And then you go into sentencing from the judge. So how were these laws applied? For case one, the law was applied with client X's status conference by determining the next steps and staying updated on any new information to be able to be taken to be able to take the case to a jury trial where justice can be served for the crimes committed. Um, Case two, the law was applied by giving client G another chance at probation by helping him fight addiction at a rehab center and to have a better life, not served behind bars with a healthy mental health. So sentencing case for case one, client X is still waiting her jury trial, which is supposed to take place in August of 2024. Doesn't mean it will happen. It's just that's when it's supposed to be getting scheduled. Um, Sentence case number two for client G, he was sentenced to go to a transitional housing and then into rehab housing due to his violation of his probation. Um, this is where he can work on his mental health and work on getting better with his addiction to opiates, so he can have a better life outside of jail. Um, so I learned a lot from these courtroom observations. So it was very interesting hearing all the cases that were brought up to the judge. So thank you for watching.